Hi, guys, and welcome. We're at week 3 of environmental law. So, this week or this module, we are going to be learning a little bit about court review of environmental law. Well, kind of taking environmental law to the courts rather than using statutes. Talking about due diligence, doing some case discussion. It's kind of what we're doing. So, for our first chapter, we're going to be talking about common law causes of action, non statutory ones. We're going to get to the statutory ones all through the semester um, and seeing, when we can sue the government, when we can't sue the government, and talk about, what paralegals do in environmental litigation. So, I like to be full screen. I don't know why. Oh, here it is. Okay. So, we all are familiar with our environmental statutes, or we've heard of them, Clean Air, Clean Water Acts, and how they have improved. They have improved our environment. But, before, the 1970s proliferation of environmental statutes, the only way a person could prevent some environmental violations or just, harm to the environment were common law, just taking people to court, suing them. So I hope this is a review, but if you are suing someone, you need what we call a valid cause of action, a recognized legal basis for a lawsuit. And that cause of action would require, elements to be present for a suit to succeed. You have to prove A, B, C, and D, and then you can recover. And then the plaintiff has that burden to prove those elements before that they can win the lawsuit. And the burden of proof in a civil lawsuit is usually what we call preponderance of the evidence. So more likely than not, think of a scale. If the scale tips more in the favor of the plaintiff can recover. And if the plaintiff tips more in the scale of the defendant, then the defendant is absolved of liability. So after we're kind of going to go a little backwards because that's the way the textbook goes. But after all of these environmental statutes were enacted, these common law claims were held to kind of be no longer viable. They said that they were preempted by these federal statutes. So preemption means that if there's a statute on that issue in federal court, so in a higher level court, right, then that would trump these local state laws, so common laws or something like that. So that's kind of the theory of preemption, right? There's a federal law on this, so the state law no longer applies. Okay, so in 2011, there was so the greenhouse gases issue and the global, the climate change issues have kind of been around for a while. When we were talking about our history, really since at least the 90s, it's been a big concern. Um, and the EPA didn't think that it had authority to regulate these greenhouse gases like carbon monoxide, etc. Um, and people were getting frustrated and kind of taking to the courts to get something to happen, right? So if the legislature is deadlocked on environmental issues, uh, people don't believe in global warming, things like that, um, and the agencies aren't doing anything, right? The executive's not doing anything. So what, right? That's your recourse is the courts. So a bunch of lawsuits went in, asking for kind of regulation of greenhouse gases or asking for, because of just general violations, for people to stop for the courts to really impose limits on the emissions of greenhouse gases. So there's, if you look in the book, they talk about this case, Massachusetts versus EPA, which again we'll talk a little bit more about when we go have our climate change chapter. But Massachusetts versus EPA says, you know what? Yes, the EPA has the authority under the Clean Air Act to regulate these greenhouse gases like carbon monoxide, and then there's some other nitric something or other. So that happened, but then the EPA was kind of dragging its feet and hadn't, regulated anything. So I think that was like 2009 or something like that, that Mass versus EPA came out. So in the interim, people again, EPA is not working, legislature's not working. Well, we're going to go to the courts. So a large group, this like ginormous group of plaintiffs from a bunch of states across the country brought a lawsuit against the five largest electric power companies. So these five power companies in the country are the largest emitters in the country of greenhouse gases. So so they alleged that they contributed to global warming to an extent that it interfered with our public rights and violated the Interstate Commerce Clause. So this is obviously in federal court dealing with the Interstate Commerce Clause, and multiple plaintiffs and obviously five defendants. So they're kind of using a common law theory to get these power companies to reduce greenhouse gas emissions. So that's kind of like your background facts there. So our procedure, the trial court said, there's not really a triable issue here. This is a political question, right? Which should be resolved by Congress. But then when it went to the appellate court, I think it was the Second Circuit, they said, you know what, the parties have standing because they have alleged injury. And this is a cause of action under what we call federal nuisance law. We're going to talk a little bit more about nuisance law in a bit. And so the Supreme, so that was great for the plaintiffs. Okay, they can file this cause of action under nuisance law. But then the Supreme Court got to it and said, no, we've held that the EPA has the right or the obligation to regulate greenhouse gases under the Clean Air Act. So since this is the purview of the EPA through the Clean Air Act, the state courts are preempted. This common law right to seek reduction of greenhouse gases is preempted by the federal statute, the Clean Air Act. So clean air, Congress addressed that in 1970 something or other in the Clean Air Act. And even though the EPA is dragging its feet and hasn't done anything yet, preemption still applies. And then the other thing they're saying, which I think is valid, is that the EPA, is a technical scientific body, right? So they have certain expertise about how to reduce emissions and what these chemicals are and how they're emitted and things like that. And the courts, they know the law. So it's really not, it shouldn't be up to the courts to impose these limits. So basically, this case failed. But then, the EPA has stepped up and started to regulate these greenhouse emissions really in the past, kind of really since like 2000. And I think the first ones were in 2009 for like cars. And they're working on it as we speak. So another thing that we talk about, and we talked about Storm Mountain. I think that was last week or maybe the week before. A party, before they can bring a lawsuit, has to have that legal right to sue. The Constitution of the United States limits the power of the judiciary to actual cases and controversies. So there has to be like an issue between two people before they they can hear a case. Okay, so it's a big, it's kind of has been historically an issue in environmental cases. Who has standing? Who has the right to sue? So some environmental statutes allow for people like you and me to sue for violations of the statute. Like, hey, this company in my town is violating the Clean Air Act. I have a right to sue vis-a-vis I have been granted authority through the Clean Air Act to sue. They call these little clauses private attorney general provisions. So if the government's not going to do it, I'm going to do it, or my neighborhood association is going to do it. Okay, so they're granting private citizens or citizen groups right to sue under a statute. So that's really like kind of open the gates, and we don't have to wait to go to the local EPA like, hey, they're violating, they should do something. Right now, if people are concerned, they can sue on their own. Okay, so when we're dealing with a common law cause of action, not a statutory cause of action, and this is something that you should be familiar with just from your other classes in the paralegal department. So you have to prove some sort of invasion or violation of a protected interest, right? And that's real, and it has to be, either occurred or is imminent. So it can't be like this could happen, right? It has to be real. And whatever injury you are claiming must be able to be redressed by a favorable decision. So, I can't sue for world peace because the court can't mandate world peace. So, those are some kind of uniform characteristics of a common law cause of action. So, some of our common law causes of action, and these are kind of fun. If you go look back in some of the old cases, where somebody is claiming a violation of their riparian rights, the rights to the water in the area. And there's a pig farmer upstream who's the pigs are pooping all over their river. And then the water coming to them is contaminated, right? So, who has the rights to that river, right? And the use of the river. And does someone have the right to pollute the river with their pig poop? So they're kind of fun, very interesting, very concrete, and things that people can, you can sink your teeth into. But they're all kind of based on some of these basic common law theories, like trespass, right? Like we've seen signs, no trespassing. So trespassing is invading the land owned by a plaintiff. So somebody comes and like spills chemicals on my property. Okay. In environmental law, it doesn't mean that you have to be able to see or smell it. So it can be that just know that it's there. That there is if you are alleging an intentional trespass, you don't even need resulting harm. You don't need to say like I'm getting sick or my kid has asthma or something along the line. So if you know that they're doing this on purpose, if it's a negligent trespass, proof of harm might be required. So like, okay, so say my neighbor is throwing his dog poop on my yard. Okay, so that would be an intentional trespass. So I could sue him for trespass to my land. Actually, this did happen. My neighbor he'd go up to my garbage can and put his poop in my garbage can. Very, very annoying to me. Thank God the guy moved. So a negligent trespass might be that, like, say somebody's doing whatever they're doing on their land and it spills over, right? So it, goes in the groundwater or something like that. So that would be a negligent trespass. So you can see how this would be helpful in environmental law, even, like smells and things like that, not just say clean water, but clean air, right? So like smells and things like that coming across into my land. So that's one theory. Another theory is nuisance. Okay, so nuisance is someone interfered with my use or enjoyment of a property in a way. So think of like, yeah, loud noises. I don't know if you've ever been in a situation where somebody's doing construction very close. So it's like really annoying. Or even the lawnmowers and the leaf blowers, at 7 a.m., right? So that is interfering with my use or enjoyment in a way. Now, does that cause substantial harm? The leaf blower, if I miss work, I don't know if, it's interfering in interference. So noise pollution is a big one. Airports, people who live near airports are always complaining about the noise when the flight paths, or yeah, even you don't live that close to an airport, but the flight path is over your house. So in to determine whether or not someone is liable for a nuisance, the courts perform a balancing test. What is the utility of what the uh, perpetrator of the nuisance is doing versus what is the harm to the person claiming the nuisance? And another thing that the courts look to is, did the party actually come to the nuisance? So if you move right next to an airport and then you complain that it's loud, you're usually barred from bringing a case. So that's kind kind of a thing, right? So yeah, it's a matter of degree. You think about like a crying baby, or I remember my son used to be playing the bagpipes, and maybe people would complain with that. Um, so you have to say, is it unreasonable or substantial? Uh, say you move near a landfill, maybe it smells, maybe there's rats. But the utility of a landfill is important, right? Society needs to dispose of its garbage. Um, what is customary in where you live, right? So if you have a crying baby or a barking dog in a neighborhood, that's kind of standard for a residential neighborhood. A giant machine that makes a lot of noise all the time or pumps out clouds of smoke, is not. And then they think about, oh, what are ways to abate the nuisance, right? Could you put a filter on a smoke machine? Could you move runways to have planes take off over non-residential areas, things like that? Um, yeah, so some states actually bar the cases where someone came to the nuisance, um, or reduce reduce recovery for that. Um, so the other issue, okay, so is private nuisance and public nuisance. So a private nuisance, you can get money, or an injunction for your recovery, right? As a person, who has been harmed by this nuisance. A public nuisance, you're claiming that the defendant's actions actually interfere with the rights of the whole public, right? And those are usually brought by, say a town or some sort of governmental body. Um, and if you're personally hurt, you can maybe sue for a public nuisance, but and recover yourself. Yeah. So this is the example they have in the book is a quarry, right? Everybody's like upset because it's loud and everybody gets dust, but one person actually lives very, very close to the quarry and gets asthma or something like that. So she can, even then she would bring that action for a private nuisance rather than the public nuisance. So also like issues of continuing trespass and continuing nuisances. So the example they give you is like some guy who buried his trash a long time ago, and the chemicals or the batteries or whatever was in the trash is now leaching into the groundwater. So that is a continuing trespass, right? Or a continuing nuisance, right? That it's not like it happens one day and it doesn't happen the other day. It happens all the time. So the issue here with continuing trespass or continuing nuisance is statute of limitations. So if he buried that stuff like 100 years ago, obviously the statute, if it's from the date of action, then that would be barred, right? But is it the date of action, or is it the date of injury? So that the courts in the states have to address um, where the statute of limitations lies. So what I want you to do now, after talking about nuisance, because our discussion is about this come to the nuisance thing. So why don't you take a break from the videos and go and look at our discussion for the week about coming to the nuisance, and then come back and watch the next video.